This meeting is being recorded.
All right, so today, obviously, we're talking about direct examination. So just like an effective opening can be a decent story, right? You can't make arguments, but the jurors kind of fill in the gaps and the dominoes should align. So when you knock one over, it'll go. Direct examination should be the same way, all right? Now, there's really two approaches to direct examination, and we'll get into that. The chronological versus kind of the impact approach. But for our purposes, direct examination is just an exercise in storytelling, right? So what is direct examination? Basically, direct examination is when you call a witness, right? So a witness theoretically favorable to your side. And you begin asking questions of your witness, right? So this is, again, an exercise in storytelling where the witness is the star. So we'll talk about cross-examination in the next class. But when you're on direct examination, as the lawyer, you want to be as minimal as possible. You don't want the jurors to really even know you exist. Right? You want the jurors' attention to be completely focused on the witness. And that's good for you, right? Because they're theoretically favorable to your side. So as much attention as they can pay to the witness, the better. Now, what's interesting about direct examination is how you can approach it, right? So some lawyers get in there and they just go, all right, what happened? What happened next? What happened next? And it's just kind of this mundane, technically a story, but doesn't really have much life to it. So if it's an effective direct examination, right? Something that actually strikes the heart of the jurors, that captures their attention. Generally speaking, you don't want to tell them what happened, but you want to recreate the scene for them, right? So again, this is largely going to be premised on how you prepare your witnesses. Generally speaking, you can't tell your witnesses what they have to say, but it's your job, if the witness just kind of starts answering in a plain, mundane manner, to elicit the scene, right? So when you think about persuasive direct examination, right, we're basically engaging the jurors' hearts and minds to build some kind of emotional connection, right? So there's a difference between saying, on the night of the 21st, I observed two males walking down the street and pulled my car over to question them as to their whereabouts. Right, that's theoretically a story, not a very enthralling story, right? Not one that you really care about. But if suddenly your witness, let's say the police officer, says, well, it was a hot, sunny afternoon. I had the air conditioning blowing. I was just doing my regular patrols when I noticed two males. One male was about 6'2", who was wearing a red sweatshirt, blue jeans, and white tennis shoes. The other male was African American. He didn't have a shirt on, but he was wearing blue jeans and white tennis shoes as well. Now, as I proceeded in their direction, just with the flow of traffic, they kept looking at my car. And as they looked at my car, they sped up walking, right, to the point that it was almost a light jog. That was enough for me to say, I think something's wrong here. So I pulled my vehicle over, I opened my door, right? Suddenly the heat hit me, but I asked the gentleman to stop. They stopped, and you go on from there, right? So you've just told the same story two different ways. One is bland, mundane, boring. The other starts to paint a picture, right? And that's what you want to do. You want to recreate this picture for the jurors, right? So it's not just, then what happened, then what happened, then what happened, right? It's what you smell, what you taste, what you hear, what you feel, what you see, right? So we're engaging all of the senses. And the idea is, as people, as human beings, we're natural storytellers, at just how we communicate. And the more effective your story, the better. Right? The more it recreates the scene, the feeling, the passion, the tension, whatever, the better. You have to understand that the jurors have certain interests and needs, right? So remember, we talked about when opening statements, the moment of primacy. Well, you'll have that generally for the first few witnesses, and then they'll start to trail off. But the first few questions, you'll get jurors' attention. So this is the time where you can really engage them. And we'll talk about two different strategies. If we want to go in chronological order, or if we want to go in for the wow factor, the impact factor. Now, different strategies are appropriate for different people. All right, so if we think about the Trayvon Martin case, if you recall, the prosecutor in the opening of the case and the first witness that the prosecutor called was the friend of Trayvon Martin who was the bag of skills that Trayvon Martin got for, right? So I mean, that right there is like, okay, you can kind of tell what approach they were going for, right? Because he might not have much to tell about the story, but if he cries about his friend, you've just engaged the jurors, right? Because we kind of feel that inherent emotion towards each other. We'll talk about jurors' intention and education in a minute, but just know that you have to talk at a very low level, right? And we'll talk about different words that are legalese versus what normal people could understand and what normal people could say. Now, that being said, again, attention span is very limited, right? So sometimes it's best to get the wow factor out first and then proceed chronologically, or to start tearing down the case or building a case however and wherever you're positioned. With that being said, attention spans become very, very, very limited with expert witnesses. All right, so an expert witness is somebody who didn't see it, didn't experience it, anything like that, but is there to testify about some kind of usually scientific test or scientific findings that they found. That's all well and good, but it's not CSI, right? Theoretically, they're there to help the jurors understand the science. So if you start talking about DNA, well, they're going to say, yeah, I use a proton 78-12 nuclear analysis analyzer. It found that there was actually 12 base pairs, and you know, it just goes on from there. And if you're not a science person, like most of our jurors aren't, you're going to start to tune this out, right? Very, very quickly. And most expert witnesses are very, very boring because they don't really have a dog in the fight, right? They shouldn't seem like they have a dog in the fight. They're there as a neutral just to explain to the jury, all right, this is what happened, right? This is what the test results show. This is how I got to the results. And we'll talk about how you qualify an expert and deal with an expert later in this course, but just know that if you have an expert witness, get that wow factor out first. Right? Then you can start going chronologically, but you're only going to have their attention for a minute or two. There are some expert witnesses who testify professionally, and that they get paid a ridiculous amount of money, and all they do is fly across the country testifying. And again, they get paid a ridiculous amount of money to be there. And to that extent, when we talk about cross-examination, we'll talk about how you cross an expert. There's not a whole lot you can do unless you're trying to show that there's bias. Usually this is, you're being paid to be here, right? In fact, you're being paid $500 an hour, plus a $5,000 retainer, right? Yeah. And you kind of go in from there, right? That's your best attack. Because the best expert witnesses are going to be the neutrals, right? Presumptively neutral. And because they're neutral, they're not telling a fun story, they're not telling a developed story, you lose attention. So, when we think about moving into direct examinations, this is where we have to start worrying about court rules, right? So, there are several types of rules. We have federal rules of evidence, the federal rules of criminal procedure, the federal rules of civil procedure. Then each state has their own rules of evidence. Each state has their own rules of criminal procedure. Each state has their own rules of civil procedure. So what I did was kind of highlight some of the biggies, right? So some of the big considerations. So one of the first things that you have to look for, right, if we kind of go down the list, Federal Rules of Evidence, that's what FRE stands for. Federal Rule 601 discusses a person's competency to testify, right? And generally speaking, it's a very, very, very low threshold. Person's competency is a very low threshold. Right? They basically have to be able to communicate, and that's all that we require for competency. Generally speaking, if we move on to Rule 603, before we get to 602, we're going to require, maybe as a part of competency, but as a part of the proceedings, that the witness gives some kind of affirmation of the truth. Right, so we've all seen in TV shows where somebody like has their hand on the Bible and says, "I'm going to tell the truth, the whole truth, and nothing but the truth, so help me God." That doesn't happen. It arguably used to, but as we've progressed, it doesn't, and that's for several reasons. The oath now omits the "so help me God," right? It omits the Bible, because what if you have somebody of Islamic faith? Swearing an oath on the Bible doesn't necessarily mean as much as swearing an oath on the Quran, right? So and obviously you have some religions where you're prohibited from swearing oaths, right? You're prohibited from it. It's not allowed. So what do we do in that case? Well, in that case, we either, if they can't swear, if they can swear, we'll say, "Do you swear to tell the truth, the whole truth, and nothing but the truth?" And maybe we'll add something in, like, with a knowledge of the pains and penalties of perjury, right? If they can't take an oath, we just generally reply with, "Do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?" Right? So again, they're not swearing, we're not violating any kind of religious tenets. We're just asking for an affirmation. Now, I know it kind of feels like we are dealing with the same thing, right? And to be fair, we are. We just call it different names to try to be as sensitive as we can, right? So again, generally, you're going to be competent to testify. You have to at least give an affirmation that you're telling the truth. And then 602 becomes a really big one. 602 is personal knowledge, right? So you have to, in order to be able to testify, you have to have personal knowledge of the events of which you're testifying. So what does this mean? This kind of lends us into hearsay, right? So you can call if you want to. Let's say there was a burglary in somebody's house and the neighbor saw everything. You can call that neighbor to testify, right? Because she had personal knowledge. She saw it. She, with her own eyes, her own ears, etc., she saw people breaking into her neighbor's home. Let's say that her husband wasn't home. You cannot call the husband to testify about the break-in. Because did the husband see it? No. Any information he got about the break-in came from his wife. That's hearsay. That's secondary evidence. We don't want that. Now, you might call the husband, or your opponent might call the husband, to maybe cast doubt on the ability of the witness, maybe their mental state, their ability to perceive things, etc. Then you could call them, right? Because that's their personal knowledge about the witness, not about the burglary. Right? And that's something that we have to keep in mind is, did you use your five senses to observe it? If you did, then you have personal knowledge. If you didn't use your five senses to observe it, then you generally don't have personal knowledge. Now again, we're making an exception for experts, because again, there are neutrals, but just you have to have that personal knowledge. It seems like one that seems very obvious, but it's difficult when you're in the middle of the case. Because you have to think to yourself, can I testify about this? Can I testify about this? Did they see this? Well, how did they find out about this, right? So again, personal knowledge becomes a very big issue. So for instance, I don't know if you've all seen My Cousin Vinny. If you haven't, you should. But My Cousin Vinny, the prosecution gets up. It's a murder case that's happening. My prosecution gets up, calls a witness to the stand. Witness is older woman, thick glasses, right? And she personally observed from her window the defendants going into what's called the Sacco Suds store, leaving the Sacco Suds store in a green, mint green metallic Bueller or Skylark, right? Buick Skylark. Okay, she can testify to what she saw. But what we're going to see is on cross-examination, we're going to say, okay, you might have seen something, but we're going to make sure that you actually saw what you said you saw, right? So what My Cousin Vinny does, Vinny gets up there with a really long tape measure. Right? He goes, about how far away from you was the Sacco Suds, were the defendants? Oh, I'd say about 40 feet, right? So he says, okay, hold this. And he runs out basically into the courtroom. Right, and then he holds up a couple of fingers, says, how many fingers am I holding up? And the judge goes, let the record reflect that the counsel is holding up 2 fingers. And the guy's like, the attorney just looks at the judge like, are you serious? So he goes, okay, how many fingers am I holding up now? And she's like, 3, 4. And then he comes all the way back up, right to her face to show her that he was holding up 2 fingers. Right? And so the question was, oh, do you need new glasses? Yeah. Right, so she had personal knowledge, but it doesn't mean it has to be a perfect perception. But you want it to be as close as perfect because on cross-examination, they're going to start tearing down your ability to see, to have preserved, to have witnessed what happened. We also have to consider rules 401 to 415. Right, so basically this includes a test for relevant evidence. So it also deals with cumulative evidence. So the idea behind relevant evidence is relevant evidence makes a fact in controversy more or less likely, right? It doesn't have to move the bar, but a tiny, tiny, tiny bit to make some event occurred more likely or less likely. Right, so if we go off on a trail in, let's say, the murder case about, well, what did you have for lunch that day? Right, we're not trying to test cognition, we're not trying to test memory, we're just asking what you had for lunch that day. The other side's going to object because that's not relevant, right? How does it make this person's guilt more likely or less likely? It doesn't. So we'd have that test for relevant evidence. That being said, we can have 23 witnesses who saw the same event. The court's probably not going to let me call 23 witnesses who saw the same thing. I might call 1, 2, maybe 3 people, and then we'll stipulate that the rest saw the exact same thing that these guys testified about. Now, if the people that we allowed to testify give completely different versions of the story, then yeah, we're going to have the rest of those witnesses come in and talk. But you can see where it can get very boring and very cumulative, right? Because you just heard the story. Now I heard it again. Now I heard it again. I got 20 more of these I have to hear? No. Right, that's kind of the rules are built. It's built not to prejudice the defendant, so basically not to harm them by having just a ridiculous amount of people say the same thing, but also it's a matter of practicality because we understand that court time is expensive, jurors get bored, jurors stop listening, so we want relevant evidence that's not cumulative. That being said, a couple things I'll get into and we'll get into a little bit later is direct examination should never be what's called leading, right? A leading question is a question that's basically answerable in a yes or no. That's the simplified version. Realistically, it's a question that gives the answer within the question, right? And the other party just affirms it. So saying something like, what do we have in your handout here? You were on guard then, weren't you? Well, the only answer is yes or no, right? You can't elaborate. On direct examination, we don't allow that, right? And you don't want that because you want this witness to be the star. Cross-examination, you as the attorney are the star. Direct examination, witness is the star. Right, so we don't allow leading. We want them to tell us what they saw. And the idea is you're not coaching them, you're not helping them along. They're telling their story, you're not telling it for them. That being said, Rule 611C permits leading questions, 1, as necessary to develop the witness's testimony, or 2, when the party calls a hostile witness or an adverse party. Right, so what do you mean by this first one? It's necessary to develop testimony. We're going to allow a little bit of latitude when we're trying to get somebody, direct their attention in some way. So we might say, Mr. McNeil, you're a security guard, isn't that right? And you're a security guard for so-and-so place. Right. Were you on duty on the night of this thing? Yes. What did you see? Right, so we have like 3 leading questions, and then we jump into what did you see? So we can use leading questions just a little bit to direct people. Now that's in court. In court, like they're going to allow you, they're going to give you some latitude, right? It's just kind of a professionalism. Like we all know what you're doing. You're going to do it, so I'm going to do it. In mock trial, if you're interested in mock trial, they're going to jump on every leading question you ask, right? Regardless of whether it comports to 611C or not. If we continue down 611C, you can see that if you call a hostile witness or an adverse party, you can lead on direct examination. So generally speaking, they have to be qualified by the court as a hostile witness. You have to make a motion to make them hostile. What does it mean to be hostile? It doesn't necessarily mean that they're yelling, screaming, whatever. It means they're there against their will and or they're not answering your questions. Right? So at some point, if you have somebody on the stand who's like, I'm not going to testify, I don't want to be here. Where were you on the night of January 7th? Well, I don't remember, I don't care. Okay. Your Honor, can I treat this party as a hostile witness? Not answer my questions. Maybe they're related to the defendant, right? Maybe they're the brother or sister. They're an adverse party. Then maybe we can start asking them questions. Right, so the adverse party exception comes up more in civil law than it does criminal law. Because in criminal law, you cannot call the defendant unless you're the defense and you want to, right? You can call them if you want, you don't have to. In a civil case, you can call the defendant if you're the plaintiff to the stand. Right, in that case, you can start leading them because you don't want them to go off on their own tangent because they're the ones being sued. So they want to tell their own story. You want to tell the story for them, right? And that's what 611C allows us to do. We also have to take consideration Federal Rule of Evidence 701. Basically, direct examination questions can properly elicit lay witness testimony in the form of opinion if the testimony is based on a rational perception and if the rational perception is helpful to the jury. Right, so generally speaking, we don't allow people to give opinions, right? Especially to the ultimate issue. Is the defendant guilty? Is the defendant not guilty? That's not going to fly. Right? But we're going to say, okay, let's say we say, so how did we're talking about breaking into a house, right? So how did the suspects appear? Well, they appeared like they were trying to be sneaky, like they were trying to hide something. That might get an objection. That's an opinion, right? But 701 allows the opinion if it's a lay witness. So a lay witness is a non-expert. It allows that opinion if it comes from their rationally based perceptions, what they saw, the rational beings, and it's helpful to the jury, right? And so you argue that motion back and forth, you're probably going to win it, I'm like, how are they acting? Well, Your Honor, they can give a lay opinion on how they were acting, right? It's an opinion. So those will generally be permissible. But again, as you write your direct examinations, try to cut down on opinion as much as necessary. Only make it when you're trying to make a point, right? Where you know the witness is going to say something along the lines of, they were acting suspicious, they were acting like they were burglars, they were acting like they were going to break in. All that's opinion, right? What I saw is different than what I think it meant or what I think they were doing. And then we have to consider Federal 612, refreshing recollection. So we'll do this in class on our impeachment day. But let's say you get a witness on the stand. Right? It's scary to be on the stand, even as a witness. Like, you're not on trial and like that, but there are men with guns standing, a few feet away from you. You're called up into this box. You're sworn in. Right? You have all these kind of what seems like angry people. You're facing the person you're testifying against, or the party you're testifying against, and you're facing what we call gallery, basically the witnesses, the families, etc. You're facing all of them. It's a scary experience. Now, because it's scary, we know that, two things. We know that human memory fades very rapidly, right? And we know that scary experiences make us less likely to remember something. So what we can do is we can engage in a process called refreshing the recollection. Right? So this kind of comes in the form if the witness gave a statement to police or gave an affidavit. Right? There's really actually no limits on how we can refresh somebody's memory. But we just say, hey, would this be helpful to refresh your memory? Like you have a witness gets up there and he goes, I can't remember what I saw. I had it in my head just 5 minutes ago. I can't remember what I saw. They're like, okay, chill. Right? If I gave you your affidavit, if I gave you the police report, would that help? We allow that, right? So even though it seems kind of like more of a, we're telling them what to say issue, we're not, right? We're just helping them remember the event and go from there. Now, if they forget certain little things, maybe we refresh the recollection, maybe we don't. Because when you do it, you run a risk, right? You run a risk that you're telling the jury, hey, this person on the stand doesn't remember anything, right? This person, they can't be trustworthy, they can't be reliable, they can't remember what happened. I have to keep telling them what happened, they can't remember. Right, so you can see where it kind of becomes cannon fodder. So again, use it very sparingly as you're at your direct examinations and with the idea that you might need to refresh their memory somehow. So, if we look at direct examinations from the jury's perspective, this is the time, generally with your first 2 or 3 witnesses, that you have a second moment of privacy, right? So basically, whenever somebody takes that stand, they're paying attention. Now, once they start talking, they start to drift off. But when somebody's like, something's moving, something's changing, because most of the time we're just standing there, asking questions. Like there's no movement, there's no nothing. Like, so you kind of daydream. But here they're getting up, they're moving, they're swearing, they're doing all this other stuff. That's a prime opportunity for you to put your best foot forward. What I mean by that is we know from studies that generally juries' impressions of witnesses will go to the credibility of that witness, right? So if we think of somebody gets called to the stand and they walk up confidently and they're well dressed, well, suddenly I, as a juror, go, okay, they seem a little bit more reliable. We might not say it overtly, but at least in the back of our head, we're thinking, okay, taking this seriously, this is more reliable. And you may call somebody who doesn't have nice clothes, right? You may call somebody who had to wear shorts because that's all they had to court, and flip-flops. Who are you instinctually more likely to believe? The guy in shorts and flip-flops or the guy in a suit? Right? So again, when you work with your clients, and you work with witnesses, give them basically a checklist of how to dress. And if they can't afford it or they don't have that, get it to them, right? Because we want, I mean, everybody thinks he's a little scared, but we want confidence. We want to see attire. As bad as that is, we judge people based on attire. Juries do it all the time, right? Because they're going to tune this person out. They'll listen for a few minutes and then they'll tune the person out. But we as a people link attire to credibility. Right, so there's a link there. It's not one that speaks well of our species, but it's a link that exists nonetheless. Now, if you want to keep the jury's attention, jurors want people stories, right? So juries want things that involve emotion, that let them become involved in that other person's life. Right, so again, this is where the best witnesses have the testimony that's just visceral and triggers emotional responses through the use of sensory language. All right, so again, using your five senses, recreating the scene. Recreating the scene. Maybe understanding what some triggers are for people. Well, officer, what happened when you arrived at the scene? Officer pauses. Blood. There was blood everywhere. It was dripping down the steps. I recall it just dripping and dripping down the steps, and me wondering what was going on, what was on the other side of that door. You could smell the blood. You could smell the iron. You could cut this tension around this place with a knife. That's a decent story. As opposed to, well, I got the vehicle, I observed blood, I entered the premises, whereupon I came upon the victim laying on the floor. Right? So again, one captures your attention, and you're kind of like, okay, I'm into this. And the other is boring. Unfortunately, a lot of trial lawyers like to keep things boring because there's a little bit more effort to get people to get sensory language. Like, tell me what happened. What'd you feel? What'd you see? What'd you hear? You know, I smelled the iron in the blood. I smelled the blood. Wow. Right? Wow. Especially, and there's a mixed debate whether we should have police seem neutral or police seem human. And I'm very much on the humanistic side, right? We don't want robots because you're not going to care. It's a human, there's a big difference, right? So what happened when he entered the home? I saw a body. It wasn't moving. It was pale white. I heard a gasp. So I ran over, but it was too late. She was gone. Good story. All right, not just what did you see when you entered the room, or what did you do when you entered the home? I went over to the body. Okay. One's professional, one's more of like the word cold and detached. One is, I have a humanistic element. And also, you want to trigger, and if you do jury research, if you have like a big trial where you're doing jury research, like death penalty trial, where you actually do background checks on the jurors. If somebody has lost a family member, even recently, like maybe like their grandma had died 2 weeks ago, talking about a dead body is going to trigger something in them, right? Grandma died 2 weeks ago. Even if you're talking about like a young man, the death is going to be a trigger. And that's kind of what we want to do to the jury. We want to do it in a positive way where they side with us, right? Where they basically build an emotional connection to the witness on the stand, our witness. Which is going to be great because on cross-examination, if they try to like tear down our witness, that juror's going to be ticked, right? Because they're going to be thinking about their grandma. They're going to be thinking about what this guy saw. What was it like for grandma? What was it like for this guy? And then suddenly you get in there and you start like just cross-examining, you're just like hounding them. it's going to set a very negative impression on cross-examination of that attorney, right, of the defendant, of whomever. So again, the more visceral and the more triggers that we can trigger, the better. All right, so we do jury research. There are jury consultants who get paid ridiculous amounts of money to help you choose a jury, right? If you want to see a movie that's actually, it's a little far-fetched, but it gives you an idea of what jury consultants do. Watch the movie Runaway Jury. It's got Dean Hackman in it. So it's a great show or movie, but it's basically all about jury consultants, right? And building this perfect jury and thinking, well, this juror is probably going to vote this way because their background shows blah, 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 right? So we kind of stack the jury. It is what it is. But we want to use that sensory language to evoke emotion. Let's see. So during testimony, jurors subconsciously reconcile the testimony of the witness with a story the jurors have already created mentally, right? So what we're meaning here is when you give your opening statement, you've created a story, right? You say, okay, this happened, and then this happened, and then this happened, and this happened. And again, you're trying to make it lively, you're trying to engage the jury. And then the other side's going to go, and they're going to say, well, this actually happened, and this didn't actually happen, but this happened, and this happened. And each juror is going to have in their head how this played out. Like they're going to side with one side or the other, and automatically. Not supposed to, but you say, well, that's more believable than the other one. And then as witnesses testify, you start to reconcile your belief of how it actually went with what the witness said, right? If the witness is feeding into what you believe, your belief's going to get higher and higher and higher. But if the witness, somebody you've emotionally bonded with, says something completely different than what you believe, you're in a state of cognitive dissonance, right? You don't know what to do. That's where we see jurors start to flip, right? And if we can see a jury flip to our side, by again, using sensory language, using great stories, then all the better for us, right? And theoretically, this should drive the order in which you call your witnesses, right? Is how do we get them to flip to our side? And then once they're on our side, then we can lay out the story that makes sense to them, right? So again, recall the case of George Zimmerman. We called the kid, right? Emotional testimony, really, really emotional testimony. But does it have anything really to do with the factors leading up to the death? No, it was just that he wanted Skittles. It was the main point we were trying to get out of him. But jurors made an emotional connection with this kid. Like he cried on the stand. Like we, as people, are generally sympathetic. So we kind of identified with this kid. But then the other side gets up, right? And if you're a good lawyer, you start to flip that person. You don't want to treat them with like, you don't want to start punching them like you do maybe insurance agents or something like that. It's a kid, you want to use soft hands. But you want to make it so that what they're saying and maybe what the jury believes said on direct, now on cross they don't believe it. All right, they're like, no, wait a second, that doesn't make any sense. That's what you want to do, right? Start out, get the juror to either believe your side or disbelieve the other side by calling your order of your witnesses, and then tell your story. So when we think about structuring a direct examination, we know studies show that jurors' attention wanes after 20 minutes. Same thing is actually true for college students. Your attention span after 20 minutes, you're gone. Right? Because you're just like, I'm tired of listening to this person, I'm tired of this, I'm tired of that. Like, it's not as exciting as I thought it was going to be, or whatever it is. It wanes after 20 minutes. So, the best questions are ones that are efficient. Right? So, effective, yes, but efficient. Right? Especially if there's time limits like in mock trial. You want efficient questions. Right? Let's get into this. Let's get into the heart of this. Let's get into the meat of this. Right? Because we're like, if we think, okay, we have a 20-minute window in which they're going to be paying attention. And yes, more are going to wane after a certain point. Later, some are going to wane before, but generally speaking, it's about 20 minutes. That 20 minutes usually includes the swearing in and all that process. So you kind of have to narrow down how closely you tailor your questions. Now, there's two basic ways to structure direct examination. All right, the first is the chronological structure. Now, this is traditional storytelling, right? This is what jurors expect. Is you're going to tell me a story, right? About what you saw, what you heard, what you smelled, what you tasted, what you thought. And then somebody else is going to get up and tell me a story about what they saw, what they heard, what they tasted, what they felt. Right? That's generally what we talk about storytelling. It's going to be in chronological order. Right? So if you're doing chronological storytelling, you have a police officer on the stand, you don't want to talk about discovering the dead body before you talk about, well, I got a call on the radio to respond to this address. Right? Because if we just jump in and start talking about the dead body, oh, you saw this dead body, and maybe use great sensory language, but then we say, so where were you 20 minutes before that? I was in my car and I received a dispatch to respond to this in the scene. What did you see when you saw the scene? It was in detail. And you went, like, wait, well, how was the body at first? Might be a powerful impact is what we're going for. But generally speaking, you're going to be like, police call, what you saw at the scene, then see the body, right? See that chronological order. So that being said, if you have a direct examination that's effective, you need to divide it into chapters and topics, right? So the first chapter you're going to use is an introduction chapter. The first topic that you're going to use is going to be an introduction. And this, ideally, is to help the witness calm their nerves, because again, they're scared, right? Help them, like, you're just throwing them softball questions. What's your name? Spell your last name for me. How are you doing today? You know, things like that, just basic softball questions. But what it does is it also acclimates the jury to this person, right? So what do you do? Well, I'm a detective. With who? The Elkland City Police. Okay. How long have you been a detective? Right, and it gives the jury basically their resume. Then we'll get some background, right? So this is, I was patrolling my vehicle, primarily in the areas between East 1st Street and West 10th Street, when I received a 911 call dispatch to respond to shots fired at a residence, 2124 Hillsdale Road, right? So we're building a background. Because, I mean, does that really have much to do with the body, unless there's like a time frame issue? Probably not, right? It doesn't have too much to do with the actual question, guilt or innocence of the trial. That being said, then we set the scene. All right, so okay, we have the background. We know how you, like, why you got there, what you were doing. We know who you are, right? So we have that in the back of our heads, and if we can do that as quickly as possible, we need to do that as quickly as possible. Because then we want to set the scene. The scene can pull people in, right? So set the scene of, this is what happened, or this is what I saw. And go into like excruciating detail, but like use sensory language, anything that's going to keep those jurors' attention, right? So you're gonna have a chapter that deals with just the scene of what they saw, or just the scene of what they did, right? Then you're gonna have actions, right? So what'd you see, what'd you hear, what'd you taste, what'd you smell? Then we go into, so what did you do, right? So if we think about supporting tools, this is what we're talking about the witness's point of view. Well, I tried to enter the residence. I tried to avoid the blood, not to contaminate the scene. The blood was all over the steps. So I went in on the left side, just barely touching the blood, so that the others could, or the CSI could come and collect the blood and do analysis. You want this in present tense, right? Because this is action. Right? This is like action movie time. So don't say, well, I did this I did this. Like, no, so I'm at the scene, right? And I see the blood. I know I can't go through the blood because if I go through the blood, it can contaminate the evidence. So I walk slowly up the side of the stairs, trying to touch the blood as minimally as possible. And then I open the door, right? Present tense, telling a story. And you want it to be fast-paced, right? So again, we're building emotion, we're building excitement for the juror. I'm like, okay, so what happened? Well, as soon as I opened the door, I saw her. As I'm seeing her, the first thing I'm thinking is, all right, where is the perpetrator and does she need help? And I make the decision to get her help before I try to locate the perpetrator, try to save her life. I'm performing CPR. When the paramedics finally show up, they take over, but they declare her dead. All right, so again, you're living the experience again, which is horrible. If you have been through a trauma, you're going to relive it. We want you to relive the trauma, but we want you to relive the trauma for the jury, right? Because if you're picturing it and you're believing it and you're thinking in that scene, the jury's going to be right there with you, right? Right there with you. So we want the journey fast-paced. There is an objection for direct examination called narrative. Right, this is basically like when somebody goes on for more than like 12 seconds. To get that out of the way and to keep the pace going, all you have to say is, and then what happened? And then what happened? Can you tell me what happened next? All right, so again, you're just little jabs throughout. They're the star. This is the action. They're James Bond. You're just kind of giving them like little hints. Like, all right, what happened next? Again, using sensory language, selective repetition. I saw the body. I saw the body. I saw the body. Okay, can be a very powerful thing. All right, but you want to be selective about what you're doing. Because if the person just keeps repeating themselves, that's one, an objection, and two, really boring. Right? They say, I'm sitting there and I'm seeing her breathe her last breath. Her last breath. Her last breath. Okay, good repetition. Now the jury's like, oh, last breath. It's like, we know what's happening. We understand where you're at. Right? If anybody in the jury's ever seen somebody die, they understand what that's like. Right? So we're making that connection with the jury. Challenging one's own witness can also be effective in the sense of you're trying to basically preempt what the other side's going to say. All right, so if you have a disciplinary history, maybe we're going to talk about it. That can be effective, kind of disarming the bomb, right? Because they're going to get up and they're going to talk about it, and we're like, yeah, we already discussed it. Here's the answer in a friendly environment. But when we're talking about challenging the perception, again, this occurs during the action stage. This can be, you said the person was breathing their last breath. Why didn't you perform CPR? And then the officer can get into, when I checked her pulse, seemed dead, I didn't see any breathing. I immediately needed to secure the scene for the safety of others, right, to go after the suspect. So you're doing a couple punches, right? But they're gentle punches to allow that person to explain why they did what they did, why they didn't do what they didn't do. Because you can bet if the officer didn't try to perform CPR, first thing the defense is going to get there with the officer and say, you didn't try to save her life, did you? You didn't perform CPR, and you're trained to perform CPR, right? You're CPR certified. In fact, the Police Academy tells you if you have a choice between catching the suspect and saving a life, you have to save the life and not catch the suspect. Isn't that true? But if we just explained it, that takes all the wind out of the defense's sails, or the prosecution sails, or however it goes, right? At this point, when you're done with a lot of the action, when you're kind of wrapping up the action, then you start bringing in exhibits, all right? Written documents. they're basically bringing, like, when we think of tangible evidence, that's what you bring it in. Where it's like, you've kind of gotten through the action, you're still in it, and maybe we're using aids and props to help us, right? So I saw the knife. Can you recognize that knife? I can. That was the knife laying next to her body. Okay, effective, right? Again, this is where we move that in. Some stuff gets really boring. Like if you try to move in insurance policies during the action phase, nobody cares. Right? They want to know what actually happened here. Witness demonstrations, or even demonstratives, so you can blow up like pictures and make them real big so the jury can see them, and you can have the person like demonstrate like where he was, what he did. You can show, you have to get permission of the court, but you can show how a fight occurred, right? So you started struggling with the suspect, right? Yeah, show me how it is. I'll be the suspect, you tell me what to do, and tell me what you did, and we'll just kind of go from there. All right, well, the first thing is the suspect, he pulled back his arm. Okay, I'm pulling back my arm. And he started to follow through. And I grab his wrist halfway through, bend it back, he falls to the ground, I yank his shoulder back, cuff him, and go from there. And you can actually do that in front of the jury. You can act out what you saw. Again, you have to get the judge's permission. We have to make sure that it's not more prejudicial than probative. Right, so it's not like unduly unfair to the other side. So once we've built our action scene, we've gotten the support that we have for it, then we move into the aftermath phase. The aftermath phase is quasi-relevant, but it's, all right, so, like I chased the suspect, we made an arrest, blah, 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 blah. It's all part of the action phase. So, you're asking this of maybe the relative of the person who died. So when you found out about your relative's passing, what did you do? I immediately went over to the house and I was kept out. When I was let in, the first thing that I did is I got that blood off the stoop. Because I couldn't see it. I couldn't bear it. Does it have anything to do with if somebody's guilty or not guilty? No. But is it effective? Is it enough to give you like a gut wrench? Yeah. So that's when we're talking about that. All right. The other way you do a structure examination is via impact. So this is very, very, very dramatic testimony at the beginning. Right. So like just hitting them with the action phase. So and the idea is we want to capture and we want to hold the jury's attention. If we start out with, so you were walking down the street. What did you hear? I heard bang. Okay. Oh, I don't know who this person is, but well, I'm listening now. Right? They haven't given me any background or anything like that. All I know is this guy's walking down the street and he heard a bang. Like, okay, I'm with you. What's going on? I'm curious now. I want to know more. Right? And the idea is, after you do the dramatic impact, the direct examination will loop back and then kind of go back into the chronology. Right? So again, you have this phrase, this statement, this action, the sensory language used by the witness, who you know is going to inflame the passions of the jury. You can fire that off first. Right? Because you want that jury to go, oh, what? What's happening? What? Because they're going to stay with you. And they're going to start listening to the story and go, oh, okay. So he's walking the dog and then, okay, I get that. Right? They're staying with you because you've kind of created their attention. This again is useful when we have witnesses to a traumatic event and with defendants in criminal cases. So if you're ever a defense attorney, never call the defendant, ever. But if you decide to call the defendant because you're dumb, call the defendant. You're going to try to evoke trauma first, But the other side's going to do the same thing, right? They're going to use that trauma, that action, that sensory language before they loop back, right? We're jumping into the action before we go to the chronology. So if you want examples, the Zimmerman prosecution star witness, a good one. And then there's a mock trial sample direct examination for you to look at and review. We still got about 5 more minutes. Let me just show you and kind of, we've talked about this, but elaborate in a little bit more detail. Remember, the witnesses are the star of the direct examination. They're the ones who are creating the action. They're the ones who are creating the tension. They're the ones who are creating the emotion. You're just there to guide them, right? So they have to give their format, their testimony in a non-leading narrative format. So that means basically, and if you're writing a direct examination, you say, okay, I want this person to say X, Y, and Z. I can't go up there and say, you did X, Y, and Z, right? It'd be awesome if I could, but I can't. If you get stuck, refer to this list. You can ask who, what, when, where, why, and how. So if you get stuck, and a lot of attorneys do this in court, maybe they don't, because most people like that, effective attorneys don't have notes, right? They're engaging, they're listening, they're responding. But if they come up to a point where they're stuck, because they want this person to say something, and they can't say leading, they will begin with who, what, when, or how. Right? Well, how did this do it? Or what did you do? Or why did you do? Right? All those are completely viable and fair. And generally speaking, that should kind of guide most of your direct examination, right? Should lead, the first word should be one of these, right? Unless you're doing like a brief summary. So you arrived at the scene, what did you do next? Right? I just summarized what he just testified to. Now I said, what? Indicating a new question. Did you do next? I'm not leading. I'm not telling them what they did. They're telling me what they did. Right? And then that's where we get into, and then what happened? Right? That happens a lot. When they're giving a narrative, then what happened? So if we have examples of questioning, this again kind of comes from My Cousin Benny. Prosecutor could ask a question. This is impermissible on direct examination. On the afternoon of January 4th, 1992, you were in the Sack of Suds convenience store in Wazoo City, correct? Yes. That's a lot different than the non-leading questions. Were you, or where were you on the afternoon of July 4th, 1992, or January 4th, 1992? I was visiting the Sack of Suds convenience store. Where is the Sack of Suds convenience store located? Wazoo City, Alabama. Right, so again, this isn't really punchy, but this is just giving us a background, right? And you see there's a big difference. This elicits this exact same information as this. So cross-examination is a lot more effective in getting us the point out. But on direct examination, we're not allowed to lead. We have to let them go for themselves. Last thing I'll say is, for jurors, you have to presume they have the education of an 8th grader. So when we pick juries, generally try to pick people who aren't that smart, because we don't want somebody on our jury who's making their decision based upon logic, factual reasoning, etc. We want them to base it on emotion, right? We also want somebody who can be disdained and cold and distant and away from the trial. We want somebody who's going to be in it, watching it like it's a drama unfolding in front of them. So that's when it's best to think of your questions as you're writing them. Will an 8th grader know what I'm saying? Right? So there's legalese and then there's the normal comparison, right? So legalese prior to the events, non-legalese before the events, right? Subsequent to, after. With respect to, omit or regarding, right? So leave with respect to, or just say, so regarding this, did you have the occasion to? That translates into digit, right? Exit your vehicle. No, he got out of his car. By whom are you employed? These are like the very just baseline questions. Where do you work? All right, not are you employed? Where are you employed? Where do you work? Say your full name. What's your name? Right, you can see one is very jury friendly, one is like very eighth grader friendly, and the other is sounds like a boring lawyer going off on a spiel. So keep that in mind as you're working in your direct examinations. Next class, I believe we're moving into cross-examination. This will be recorded, posted online, so you can look at it. You can look at it again. If you have any questions, comments, concerns, please do not hesitate to reach out to me. I am always here for you.